All right, court is calling 2024 CR 5226, State of Texas versus Clinton Camacho. Can I have parties announced for the record for the state? Defense?
The attorney of record is Monica Guerrero, Joseph Stateston standing in, and Mr. Camacho. Will you give the court permission for me to do this in place of Ms. Guerrero?
Yes.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Camacho, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I understand, Judge.
All right, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes,
All right, Mr. Camacho, did you review the document entitled Court Admonishments and Defendants Waivers and Defendant's Affidavit of Admonitions?
Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, I understood.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I understood.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, I understood.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was sane at the time of the offense?
I believe so, Your Honor.
Mr. Camacho, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I understood, Judge.
According to the plea, there's a $1,000 fine to be probated, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, I understood, Judge.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understood.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 120 hours community service restitution, and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I understood, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Judge.
State any evidence?
Anything that might attach to, sir?
Any objections?
No objection, Your Honor.
Mr. Camacho, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Judge.
State, you may be excused.
No.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there will be no live testimony. Did you understand?
Yes, I understood, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with
Yes, Your Honor.
anything you wish to say on behalf of your client?
We ask that you follow the recommendation.
All right. I have a few questions for you, Mr. Camacho. One of the questions I'm going to ask the facts of the case because you probably have an attorney on that case. It's in regards, counsel, to the assault bodily injury warrant he had. Do you know the outcome of that case?
I believe this was the only case visible.
Okay,
If I may check with the state to see if
Yes.
there's another case pending. I thought it was closed.
Not ending, Your Honor, all of the sentence.
all right. And then what happened to your wrist?
I broke it. I was staying in a motel and they locked the exit, so I jumped the fence. And when I jumped the fence, I got caught on the fence, my shoe, and it twisted my knee. My
All right, was
wrist
that
twisted.
during this altercation or something else?
No.
So who locked an exit?
It was on Broadway. It was a motel on Broadway. I don't know.
So why were you hopping fences as opposed to going
I
through?
was gonna go through, there was only one entrance,
Mhm.
so there was only one exit, so I just jumped the fence.
All right, and how long ago was that from this incident?
Maybe 3 days prior to that.
Why didn't you go to a doctor before then?
I
I mean, broken wrists don't heal on their own.
yes,
All right,
I was told that if I didn't go that same day, that it was kind of like, it wouldn't have helped my situation with my wrist. It would have stayed broken because I broke it in 2 places.
oh no.
So if I wouldn't have got like immediate emergency help or whatever, I wouldn't have.
Who told you? I'm just curious, who told you that information?
That's the VA when I went to go show them my wrist. And
No, because my understanding, I could be wrong, I'm not a medical doctor. But what I've been told, if you need stitches and you don't get those immediately, then they're like, what can we do?
yes,
But for a broken wrist, it's going to heal improperly, potentially. And you know what they're going to have to do? Have surgery and break your wrist to put it back together again. That's just based upon documentaries that I watch. I don't know if it's true. I'm not a medical doctor. And for the record, I'm not giving him any medical advice, but you need to have that wrist looked after.
yes, ma'am.
All right. So you mentioned VA. Are you a veteran?
Yes,
All right. What branch?
I was in Army.
How long?
3.5 years.
So why are you at this place and no longer in the military?
Wrong choices, I guess.
All right. How many children do you have?
I don't have any children.
All right. And iguanas, burritozilla, am I pronouncing that correct? Or is it
According to-
burritozilla?
I believe it's just now called iguanas.
Oh, why do they put burritozilla like they sell burritos?
Client says that was a food truck and now it's actually a restaurant and they just say iguanas. I'm not certain.
Okay. All right. When's the last time you were employed?
Temporary agency.
Yeah, I work in temp, so it's on and off.
And he does receive military disability. So he may not be able to have
Okay.
other types of work.
So what's your disability from the military?
1,300 a month.
No, I'm sorry. Why are you on disability?
Oh, I have a slip disc and I have PTSD. I get nightmares.
You say PTSD, slip disc, and what else?
I have nightmares. It's my
Okay.
consists of my PTSD.
He was deployed to Iraq in 2009, 2010.
All right. All right. Is there anything else you think I should know about you before I put down conditions? Okay. Who would you be staying with if you were released?
But I'm probably gonna be staying at the GI Forum for homeless vets first, and then I'm gonna try and get a number.
Okay. And with regards to these drugs, how often had you been using?
The other day.
All right. And does he have any other priors other than this? And
There-
the assault case?
No,
Anything
there's-
else?
Yes, Your Honor.
What else?
I would have to refer back to the state's file.
All right. Is there any violent offenses?
To my knowledge, there is another possession of controlled substance case that he had during his military service.
All right. So any other violent history? I see that you have the assault. And from the way it's labeled, it appears that it was a misdemeanor assault.
I believe so.
Do you have any other violent offenses? And when I say violent offenses, anything that's aggravated, anything that involves hitting someone or anything of that nature?
No,
So other than the assault in this drug case, do you have anything else? Right, ever been to prison? All right. And just let me know if there's something different, Mr. Stateson. All right, so I'm gonna sentence you to $1,000 fine. That's gonna be probated. Sentence you to 4 years deferred adjudication. Let's do a referral to felony drug court. That'll be first. Because it's Monday, they'll be able to see you before the week is out. And so I'm gonna have that done in custody. And the reason why is because felony drug court will be able to help you with housing, will be able to help you with any other issues that you're having.
Appreciate that.
As opposed to me just sending you out, good luck. Hopefully they get you housing. They'll be able to help right away. All right, and that referral is going to be in custody. And so, as I said, they'll be able to see you this week and they'll be able to let the court know whether or not they're accepting him this week.
Appreciate that.
You're welcome. We can do, if they don't accept him, we can do a referral to Veterans Treatment Court out of custody. And we'll do a TAP evaluation in custody. How long is TAP? All right. So if felony drug court accepts him or felony drug court does their own TAP, we can just go along with their TAP recommendation. Usually if felony drug court is unable to accept you, they'll send to the court their recommendations. So we'll do a TAP evaluation, proof of employment or military disability within 30 days. So either you provide proof of your military disability or you're going to have to get employment. You understand?
It's my word.
All right. And if there is an issue where you can't provide that within 30 days, counsel, just let us know and we'll see what we can do.
Yes,
There's to be no employment as a home health care provider with minors. We'll do a MIC evaluation, 120 hours of community service restitution. What are you planning on doing with the rest of your life? Like, what are your hobbies or what are you interested in?
Actually interested in starting a business, so I'm gonna try to start getting my credit. I've been trying to get my home loan for the VA, so I need to get my credit.
All right. So what type of business do you want to start?
I wanted to start a brick oven pizza place.
All right. So 120 hours community service restitution. That will be waived if you complete some sort of culinary certification. There's going to be field visits 1 time per month for 4 months. And I'm going to want 90 sober meetings in 90 days. There's to be regular reporting by Zoom or in person and regular random UAs. And there's to be no unsupervised contact with minors. So here's the thing, if you have nieces or nephews, their guardian or some adult needs to be around them. And the reason why I'm doing that is because until you are sober, I think it's probably for the best. So once he has some months of sobriety behind him, that could be changed if you come back to court counsel.
Right.
All right, probation. Is there anything else he needs? Oh, I'm sorry. One final thing. The police were called because they said you were loitering at iguanas. So I'm not going to allow you to have contact with them. Okay. So there's to be no contact with iguanas, and it's Burrito Zilla, and no contact with 4205 Fredericksburg Road. All right. Is there anything else you need from the court?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, I understood.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understood.
All right, we can go off the record. So if there's anything you need, just let the court know if you feel as though probation is not addressing it.
Appreciate it, Judge.
All right, so what is going to be your specialty?
Pizza.
Pizza, all types of pizza?
I really want to make like Mexican pizzas, like, you know what I mean?
Okay, what's a Mexican pizza?
Queso flameado, like pizza.
Okay, now, what did you say?
Yeah, that's-
What did you say?
I have it's
No, I mean, you said something in Spanish.
queso flameado. It's goat cheese
Mhm.
with chorizo, and
Mhm.
I want to put that on a pizza.
Okay.
Yeah, a couple things.
All right, well, we'll have to order it and see how it tastes. But here's the thing, if we order it, we're going to be honest in our, our taste testing, yeah. But I'm sure it'll be good.
Your Honor, it was a criminal trespass resisting misdemeanor,
Okay,
but the ABI appears to have been family household.
All right, so then felony drug court should accept you. You just need to be honest with them. And I know that program is a hard program, but they will truly help you with any mental health issues. And they will also help you with housing and help you get your life on track. Who knows? They may send something to me and say, try Veterans Treatment Court. The only reason why I didn't recommend Veterans Treatment Court first is because it does take them, it seems, months to decide to accept someone. And I don't want you sitting in jail for months. Okay.
I appreciate that.
All right, thank you.
You have a rest of your day. Judge.
All right, you two, on two cases, correct?
Sure.
All right, court is going to call 2023 CR 8725 and 2023 CR 8727. State of Texas versus Terrence Bowie Jr. Could I have parties announced for the record for the state? Defense?
Scott McCrum for Mr. Bowie.
All right, are you Mr. Bowie?
Yes, ma'am.
Counsel, have you received all the discovery in each of these cause numbers and did you review it with your client?
Yes, I have and I did.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Bowie, did you review the documents entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in each cause number, or are you proceeding on the indictment as presented? Okay. Okay. And the cause number and the cause number ending in 8727, it appears that you're proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. Is that correct?
That is correct, Your Honor.
And in the cause number ending in 25, it appears that you're proceeding on count 2. Is that correct?
Yes, Your Honor.
Yes.
All right. And counsel, the court knows that you're not the party who put the plea paperwork together.
They didn't follow my guidance on writing it down, so
All right.
that will be talked about.
All right, Mr. Bowie. I'm sorry, counsel, do you have any objections to the state proceeding on the lesser included offense and waiving counts in each of the indictments?
No objection.
All right. Mr. Bowie, did you review the documents entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions in each of the cause numbers? With your attorney, did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 27, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 25, the state is proceeding on the possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement in each of these cause numbers, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And that you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, the court could find you guilty? And in the cause number ending in 25, the court could sentence you up to 20 years in prison. And in the cause number ending in 27, the court could sentence you up to 10 years in prison. And in each cause number, the court could sentence you up to a $10,000 fine as well. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense in each cause number?
Yes, I do.
Mr. Bowie, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial, silent on your applications. The cases will run concurrent and they'll take in consideration 2023 CR 8726 Right, the court is calling 2016 CR 0791 State of Texas versus Wesley Darnell Mulkey. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
David Andre Woodard for Mr. Mulkey.
Are you Mr. Mulkey?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Wesley Darnell Mulkey who was placed on community supervision in 2016 CR 0791 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on October 17th, 2016 for a term of 5 years and extended for a total of 3 years?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 1 on or about the 17th day of March 2024. In Bear County, Texas, the defendant Wesley Darnell Mulkey committed the offense of driving while licensed invalid in violation of condition number 1.
How do you put to that, true or not true?
We'll waive the remaining violated conditions.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, and sentence you up to 8 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court is going to find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's to grant the motion to the revoke and sentence him to 2 years in TDC, Your Honor.
All right.
That's our agreement, Judge. We're just asking the court to follow it.
All right. The court is going to find you guilty. The court is going to sentence you to 3 years in the prison. The court will give you credit for any time served, and the court is going to ask for the therapeutic community. Are there any other credit he would receive?
You wouldn't, Judge, but I believe the agreement was for 2 years. I know the court does not have to follow the agreement. But we would just ask the court to follow the recommendation of 2 years if possible. But there's no other time he would be getting.
Judge, he did successfully complete SATIF. There was 2 time frames, one for 119 days and one for 42 days.
All right, the court will give him credit for any inpatient treatment that was successfully completed. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because this was not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion. All right, we can go off the record. Mr. Mulkey,
Yes, ma'am.
I see that this motion to revoke wasn't signed by the court. It was signed by Judge Flynn, which means that you were in felony drug court.
Yes, ma'am.
You're gonna have to do better, otherwise the last time you use may be the last time you use. You understand?
Yes, ma'am.
All right, good luck to you, okay? Joshua, tell us,
Yes, Your Honor.
but y'all are on this side.
Yes.
And where's your client? Come forward.
Yourself to the judge.
Your Honor, I'm Miguel Esparza. I'm
Hi.
an officer with Cutter and Associates,
So are you in law school or where are you attending law school?
St. Mary's.
Oh, wow, what year?
I'm a 2L now.
2L? Oh, well, you're practically done.
Yeah, almost.
Well, please, whenever you want to come down, you're more than welcome to come down to the court.
Thank you.
You're welcome. All right. Who is the prosecutor on, how do you pronounce your last name?
It's Thayes. It's like TH. It's pronounced THE.
Tayez. All right. So if y'all will move towards this way, because counsel, you're on this side and your client is in the center.
How you
The
doing?
double
today, Ms.
L's,
Boyd?
I'm doing great. The double L's always get me.
Yeah, the E has that little apostrophe on top of it, so yeah.
Well, we're gonna blame it on that because in the documents, they don't have apostrophe over the E.
Yeah.
So Tayez. Do you all have the motion?
We have the motion as well as the agreed order, Your Honor.
All right, so if you could give me the motion, thank you. All right, court is calling 2020 CR 2266B, State of Texas versus Joshua Tayez. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Your Honor, Anthony Bancroft standing in for Miss Lee Cutter,
All right, and then you have with you also,
and I have my.
You wanna
Ms.
announce?
Butler.
Miguel Esparza.
All right, thank you. And are you Mr. Tellez?
I am.
All right, Mr. Tellez, you have an attorney who's standing in for Attorney Cutter. Do you have any objection to your to this attorney standing in for Ms. Cutter for this hearing?
No, ma'am.
All right, so we're here to set a bond. He's on deferred adjudication, so he's entitled to a bond. It's my understanding that the state and defense have reached an agreement of $10,000. Is that correct?
That is correct, Your Honor.
That's correct, Your Honor.
All right. For the record, the court is aware of the defendant's history because he is on deferred adjudication out of this court. And the court has done the appropriate research that's needed in order to set a bond. The court will find that the bond in the amount of $10,000 that has been agreed upon by the state and the defense is an appropriate bond. Now let's talk about conditions. Based upon your history, the court is going to order that you do weekly UAs with probation until your case is heard. Do you understand?
Yes, ma'am.
And we're going to set this. Normally, we need a hearing, just set it for a contested hearing. I don't know if it's going to be contested or not, but we'll put it on a contested date and we're off the record. All right, we're coming back on July 11th at 9 a.m. and that will be your hearing. I am telling you this. I always keep an open mind on everything, but between now and then, if there's some issues in the motion to revoke that need to be addressed with you doing certain things, it would probably be in your best interest to do those things. And when I put on here that you're to do weekly UAs from now until then, you had better do weekly UAs from now until then. You understand?
Is there a designated day or do I just go
Oh,
on that?
probation is going to let you know. So they're going to keep you out here till you talk to probation. And Ms. Ferguson, if you can give them a reset
Yes,
form.
I'm doing, I just need the file, Judge.
All right, here you are. All right, that will be it.
All right, Ms. Boyd, you have a good day.
All right, thank you, you too. Calling 2024 CR 3778, State of Texas versus Vince Ventura Ibarra. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Orlando Castañon.
are you Mr. Ibarra? Counsel, have you received all the discovery? Did you review it with your client?
You have, Judge.
Court will find that the state is in compliance with discovery. Mr. Ibarra, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Judge, we're gonna waive count 1 and go on count 2. And we're also waiving the repeat offender enhancement allegation.
Any objection?
No, Judge.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand and count to your charge of possession of a controlled substance penalty group 1, 1 gram to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Ibarra, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
Ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sure did. Yes, ma'am.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State documents exhibit one and all attachments.
No objection, Judge.
All right, did you review the document? State you may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything that you wish to say on behalf of your client?
Just judge that, believe this is a fair agreement. He understands he has an addiction and that he is looking to address that. He does have a parole case that we asked that this be run concurrent with. That cause number is 2022 CR 2107. And he's currently out on parole and awaiting a revocation hearing on that.
All right. The court is going to find you guilty. Court will sentence you to 4 years in the prison. Give you credit for any time served. There's to be no contact with Margaret Marie Gomez. This is run concurrent with 2022 CR 2107. I'll request the therapeutic community. The therapeutic community does not increase the length of time you're in custody. It's just a program that potentially could help you if you're accepted into it to kick your drug addiction. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
35 years old.
All right, so you're getting close to where you're going to have more of your life behind you, in front of you. You're going to have to make some decisions on what you want to do with the rest of your life. If what you want to do with the rest of your life is spend the rest of your life incarcerated, Texas will definitely provide a prison for you. You understand?
Yes, ma'am. Sure.
All right, good luck to you.
Thank you, Judge.
You're welcome. Isaac Cabello.
Judge, that's my case. It's an agreed travel permit. I talked to Jason Garrett and he agreed to it.
Okay. All right, we're going to go back on the record in 2022 CR 4932B, State of Texas versus Oscar Martinez. Could I have parties announced? All right, and we're on the record because there needs to be an item that needs to be relabeled. Is that correct? And defense, do you have any objection to your client not being here for the relabeling of the item? All right, so Officer Arriaga's report will be changed from defense exhibit number 3 to defense exhibit number 9. Is that correct? And it's the court's understanding that defense exhibit number 9 was never admitted into evidence. That's correct?
Yes, ma'am. That is correct.
All right, thank you. Anthony Cochran, come forward.
Good morning, Judge.
Good morning.
I do like the yellow.
Oh, you know, my mom had a yellow rose of Texas and it grew so high, it grew to the rooftop.
Oh, wow.
Yes, and then my mom had someone moved it,
And it didn't make it.
didn't make it.
We had one at my parents' old house. We didn't try to move.
Yeah, but the roses were
Uh-huh.
huge.
You just when it gets that big, they get.
Yes. Now they say with roses, they've started, I don't know what the other term for it other than breeding. Well, they've been cross
Mhm.
referencing it. So they're trying to take the scent out because it attracts the bees and everything. I guess people want that. But if you look at roses now and sniff some of them, usually it's only the antique roses. They'll still have
Mhm.
their strong fragrance, but a majority of them don't.
So
And I'm just, yeah, it is. It's like, guess what? Let the bees find where they need to go.
we need bees too.
Yes.
Normal bees is a bad thing.
Yeah.
Judge, I represent Mr. Cochran on 2 cases. They're both active. I've looked, there's over 40 videos on one and over 35 on the other. I'm through looking at about half of it right now, so I don't really want to sign a discovery acknowledgement just yet, because I'm not sure if there's other stuff that I need to request.
All
from
right, who
the
you
state.
conferring with?
I've conferred with Jason this morning. I can't advise my client to take or not take a deal
No,
yet.
no, no,
so-
I'm just trying to
Yeah.
figure out if an offer was tendered.
No, I didn't ask for one, to be
Okay.
fair, but we did talk and I explained to him, we've been going through, watching the videos at the office, so.
All right, so I'm gonna give you all a 30-day reset. This
That's
is gonna be the
perfect.
last time.
Okay,
And then at the 30-day mark, the state will need to tender an offer. Then what will end up happening is your next date after that will be a plea deadline date.
Yes, ma'am.
I'll explain all that to him.
All right,
Thank you so
thank
much.
Thank you.
Judge.
What date, Ms. Ferguson? 30 days? Yes. All right, July 16th. All right, July 16th.
Okay, and then that day I'll sign the acknowledgement. And we'll get
All right.
ready.
You're welcome. Once you sign the reset form, you're excused. Where are we on discovery?
Judge, this is the first setting. We do have a lot. I'm trying to make sure I have all of the body cam footage for every single officer. It's a lot to go through, so I'm still working on it. I have a lot, so I may have it all, but at this point, I'm not confident and able to tell you that I'm not missing things.
All right.
I did file a motion to suppress on this case. I'd like to have a hearing before trial if possible.
Motion to suppress what?
Statements.
All right. Of your client?
Yes, Judge.
Okay. All right, Ms. Ferguson. On this case, recall it for discovery. Mr. Camarillo, we're gonna recall this for discovery in 60 days to give your attorney to make sure, time to make sure she has everything. And state you believe you've uploaded everything?
I just checked the case out on Thursday or Friday of last week. I believe most of the videos are there, but again, that's not to say that maybe one's missing or something. And if it comes to light, we can definitely obtain it.
All right, if you're, Norma, a 60-day reset.
60 days runs on a Friday, Judge, so I'm gonna put it for August 19th. It'll be a Monday.
All right. We'll be back on August 19th.
August 19th.
Do you have any questions?
No, no.
All right, so we'll bring you back on August 19th. What's going to happen on August 19th is just a date to make sure that your attorney has everything about your case. You understand?
Yeah.
All right, thank you.
Thank you, Judge.
You're welcome.
Go have a seat.
All right, court is calling 2023 CR 2172, State of Texas versus Satara Portillo. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanne De Hoyos. Joseph Stateson standing in, and Ms. Portillo. Will you give this court permission for me to do this in place of Ms. De Hoyos?
Yes.
All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satari B. Portillo who was placed on deferred adjudication in 2023 CR 2172 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35 on or about the 25th day of March 2024 in Bexar County, Texas. The defendant, Satara B. Portillo, who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 35? Court will find violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor, it's altered amend for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all, if you want to reconsider things, you can, but I'm not following that agreement.